doing? Hope you're good. Hope you're fine. Hope all is well with you. You're welcome to today's class. So we're looking at the judgment of a court, its nature, types, and we're also going to look at the sleep rule. You ask yourself, what is a judgment? Well, if you're a returning subscriber, I appreciate you. If you're new to this channel, please you're welcome. This is Lawyers Info Hub, and I'm your guest. I'm your host, Mercy. I am always happy to share legal tips and concepts on this platform so as to help you who is out there, to increase in knowledge, value for yourself and for your work. So if you're here to subscribe to this channel, please hit the subscribe button. You can also share the video, drop your comment, like the video, and we want to also get your feedbacks where necessary. So today we're looking at the concept of judgment. Now ask yourself, what is a court judgment? A court judgment is the final decision a court gives at the end of a matter. After the court have heard parties, the lawyers, the evidence, everything, that's the verdict of the court. Now, you see that it is a law that every judgment must be obeyed, and every judgment becomes effective from the date of its delivery. And a judgment is valid unless it is what set aside by a higher court. Um, it's also important that when a judgment has not been set aside, it is still subsisting unless it is set aside by a higher, court, other the court that gave that judgment. So it is still valid and it is still what subsisting. Um, Now you must also understand that beyond the nature of a judgment, there's something called certificate of judgment. You have to understand that a judgment of court supersedes that certificate of judgment and like writ of attachment. Sometimes when people want to, do attachment, maybe just enforcement of judgment, that's when you see writ of attachment and the likes. So, but the judgment of court supersedes what we call the certificate of judgment. So, the case of Alaji Shaku Yakubu against Omola Boje is a 2006 3 Nigerian Weekly Law Report, part 966, page 195 at 240 is also very um, important here. So it explains this part of certificate of judgment and the judgment, which one supersedes each other. Now let's now look at the nature or the types of judgment. Yes, the types of judgments that we have before we now come to the sleep rule. Because a lot of people have been hearing of sleep rule, don't understand what it's all about or what it entails. Now, one of the first type of judgment we have the declaratory judgment. Yes, declaratory judgment. What is a declaratory judgment? A declaratory judgment is um is a solemn declaration of a status by a court. This is more like where a court maybe declares somebody's rights or declares the status of somebody. That's why it's called declaratory. Now, a declaratory judgment is complete in itself since the relief is just declaration to declare that I'm the rightful owner of so thing. Declare that I'm the rightful person to sit on the stool of so kingdom, maybe types of maybe title, is a ship thing, over stool issues and all of that. Leadership also. Just if it's a declaratory judgment, it declares the status of somebody. You are entitled to this or you're entitled to that, or you have the right to this. So it declares the status of a person, and it is in itself complete because since the relief is just declarative, just declare the rights, declare the benefits of so person. You have to also understand that declarative judgments cannot be stayed because it's just mere declaration. Um, as much as declarative judgment just declares the status of someone, it's there's the need for discretion to be exercised in making declaratory judgment. Because discretion is part of equity, and it has to be for a judge who is making declaratory judgment, he has to make it judicially and judiciously. Now, um beyond the fact that a declaratory judgment cannot be stayed, I've also mentioned that it proclaims the existence of a legal relationship or a legal right, hence it cannot be enforced. Now we have another type of judgment called the executory judgment. Executory judgment declares the rights of a party and now proceeds to order the defendant or other party to act in a particular way. Declarative judgment just declares the right of a person. This person is entitled to this. But for an executive judgment, beyond declaring those rights, it goes forward to declare, to state what the other party is supposed to do, how the other person is supposed to act. Is it to pay damages? Is it to refrain from doing something or refrain from interfering with this person's right? So an executive judgment beyond the declaration, it proceeds to order what the defendant should do or what the other party is supposed to do or how they should behave. Now, it is only executory judgment that can be stayed. Just like I earlier stated that the declaratory judgment cannot be stayed, but the executory judgment can be stayed. Um, because beyond the declaration of right, it goes further to state how the other party should or should not behave. We have another type of judgment called consent judgment. Consent judgment, it has a more and higher efficacy and binding effect than ordinary judgment. Why? Because it involves the consent of two parties, where both parties sat down and having sorted out their issues, everybody has discussed and said, okay, let's agree to that. Everybody signs it, everybody signs the terms of settlement. It feels that it has more power because it is emanates from the consent of parties. Now for a party who once agreed and later is coming to say, I'm not sure I'm agreeing again, or I was pressured to agree, or I didn't know what I was doing when I was agreeing. You have an odious task to do to to be able to convince the court to like set that aside. you know and it's important to state that when you allege there is fraud, I was fraud, or I was forced to do this. The duty is very heavy on you. Um, let's also look at the case of Dana Impex Limited against Adero Toyo. It's a 2006 3 Nigerian Weekly Law Report. Excuse me, part 966, page 78, at 100 to 101. You must also know that the consent judgment is as effective in law as any other type of judgment that was arrived at the end of the full trial, um, arguments here and there. Now, um, a consent judgment may be set aside by the court that gave it or another court of competent jurisdiction. Now, where there are grounds, that a contractual agreement could be voided or rescinded. Now, there are circumstances whereby a court that entered a consent judgment may set it aside, but you have certain things to prove. And in certain instances, um, a plea of res judicata can be entered in a consent judgment. It can stand, yeah, in certain circumstances. Now, for a party who's agreed, who is saying, I was forced to enter into a consent judgment, I I didn't understand. You're just alleging a lot of things. You have to. There are methods to challenge the consent judgment. If you are claiming it was obtained by fraud or mistaken, you were mistaken, fraudulent misrepresentation and all of that, you can appeal against the judgment or you file a fresh suit asking the court to vacate its judgment. Now, let's look at another type of judgment. It's called the undefended or summary judgment. Yeah, the summary judgment. This is where a claimant is claiming for a recovery of a debt, a liquidated money demand. That is in terms of the exact sum, that the full ascertainment of the sum. You know, So you may find your processes and you're asking the court, stating grounds why the court should, enter summary judgment. Now, it's also important to know that you have to state your good defense in your affidavit. Why should you be entitled to this sum of money? It's a special procedure, so you must state valid reasons in your affidavit why you're entitled to that sum, and because the sum is already ascertainable. Um, Now, it's also important to know that where the defendant on his other part shows he has a fair case to defend, he has a good, reasonable grounds to set up a defense against your request for summary judgment, he can be given leave to defend. It's also important to note that as much as a lot of people will want to go through the summary judgment route, you must be able to fulfill, you know, all the conditions before the court can grant it to you. What are your reasons? And the court must determine it. Now, a summary judgment can also be a default judgment. A default in the sense that maybe defendant was supposed to file the pleadings and the defendant didn't file. So a judgment can be given in default of pleadings. You know, Judgment can be given in default of pleadings, where party was supposed to do something, did not file, and the evidence before the court that this person has been served, and the person has refused to come and enter a defense in the court can enter judgment. In default of pleadings. We also know that there's another one. We have the judgment on the merit. A judgment on the merit is like a concept in the sense that a judgment on the will is one that is obtained after full trial. Judgment on the merit, parties argued, evidences were led, and to be admitted, and on the scale of justice, the court ruled, made a decision. So you can say that that judgment is a judgment on the merit. So it's not like the judgment on default of pleadings, where court just was gave his ruling or gave his decision on the evidence or whatever presented just by one party. Now, when you hear um, a lot of people mistake concepts like ratio decidendi and obiter. And why a lot of people know it, while some other people mistake what it is. Now you see that a ratio decidendi, is the reason relied upon by the judge. Why? What is those reasons relied upon by the judge for the judgment? When a judge delivers a judgment, you see in this ending part, God will give reasons why, just supposing the law, the facts, and everything. The judge will state the reasons why I'm giving this judgment. So that is the ratio. Now, why the beta? Obita is just a passing mark. Maybe the court just makes a mark or a comment while delivering that judgment or writing that judgment. So those other remarks are called passing remarks, are called the obita. It has nothing to do with the life issues for determination in the matter. Now, in the principle of stare decisis, which propounds that the lower court should follow the precedent of the higher court. This is literally, you know, if, for example, the court has ruled on this, you are now urging the court, the Court of Appeal have ruled on this, as the High Court are supposed to follow this way, this leading of the Court of Appeal, where is it subordinate courts to follow decisions of higher or superior courts. Now, under that principle of stare decisis, you cannot, an obiter is not binding, you know, but it can also be used as a persuasive force in your argument or whatever. It is only the ratio decided, that is the reason for the judgment, that can be, that is binding. It's also important to know that the concept of concurrent judgment, when you hear about concurrent judgment, now when maybe in a panel in the appellate court, one person writes the lead judgment, and other people who are in support of the judgment to also write their own perspective to the judgment, or their own judgment, that are called concurring judgment. It has equal weight with also a leading judgment. The concurring judgment complements, it adds to the leading judgment. It could be at times an improvement. The judge or justice who wrote the leading judgment will have done a wonderful work. So the concurring judgment not just adds, nourishes, complements, is an improvement sometimes to the leading judgment. Now, Now, it's also important to note we have the dissenting judgment. Dissenting judgment is the opposite of a concurrent judgment. It could be in a panel of five, three people, okay, one person writes the lead judgment, two other people, or two other people, or three other people, to, does like a concurrent judgment by complementing that judgment. Another person is saying, no, I don't believe what you wrote is the true position of the law, or I see it in a different view, and these are my reasons. Having stated that one, so it's called a dissenting judgment. Is the opposite of you know a concurring judgment. Now, also have concept of conflicting judgment. Sometimes we in our jurisprudence, you have seen maybe two appellate courts in issues of the same nature, two decisions were given. That's called conflicting judgment. So where there are conflicting judgment, the later in time prevails. Later in time prevails. Yes, where there are two conflicting judgments. Now, where there are two conflicting judgments on an issue, the lower court is free to choose which any of the decision which appears to him to be correct. Yeah, but where there is a conflicting judgment, the lower court is at liberty to choose which other one appears to him or that is correct and choose to follow those ones. Like the case of NEPA and Honor is a 1997 one Nigerian Weekly Law Report, part 484, page 680 at 689. So, friends, we'll be able to discuss what a judgment is, which I said is the decision of a court at the end of a trial, at the end of the court have heard parties talk, discuss, argue, present their case. So the decision the court gives at the end of the case is called judgment. Look at the nature of judgments. We looked at the various types of judgment, starting from the declaratory judgment to the executory judgment. Look at the consent judgment. Looked at the summary judgment. We looked at default judgment. We also looked at concepts of the obiter, the decidendi, the ratio decidendi, and the obiter. What is a ratio decidendi? We looked at all the concepts. What is the beta obiter? We also looked at concepts like concurring judgment, dissecting judgment. So these are the things how we have looked at. Now, it's also important. We mentioned that we're going to talk about the sleep rule. The sleep rule. What is the sleep rule? A sleep or under the sleep rule, it connotes an accidental sleep or omission, clerical mistake. Now, when a judge has delivered a judgment, there might be mistakes. Sometimes you collect the certified true copy of judgment, you see that the name of the parties were not correctly spelled, or some there are some mistakes in terms of maybe suit number, some just clerical accidental mistakes. Maybe the court puts the name of the defendant counsel as claimant counsel, or that something that's just clerical mistake that does not touch to the weight or the gravamen of the judgment. So under those circumstances, the judgment can be corrected. Now it's also important that now whether the correction to be made amounts to a mere sleep is dependent on the consequential effect that will arise from the correction. Now, a sleep, just like it's called a sleep, it must not be fundamental in nature. Sleep is just occasioned by a mistake, or accident, something that is not deliberate. So it's amenable to amendment. So it should not be fundamental in nature. It must not now transcend into the entire proceedings to not have a devastating effect on the judgment. It's not be something that when you change it, it now affects the judgment or changes what the judgment was initially represented initially to another thing. So under the sleep rule, a judgment of a court, the ruling of a court can be amended. And if we've seen people arguing in courts that whether it's under this can be corrected under a sleep rule, whether it's a major amendment and all of that. But whatever it is, the idea of sleep rule is that you're just correcting clerical mistakes, accidents, something that is just not too fundamental but trivial that can you can just correct. Sometimes even judges by themselves so moto can correct something. If, for example, looks at it after it have been typed by the secretary and they look at it and say, no, 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 this is wrong. So a research assistant can also notice it even without making reference to or letting the parties know counsel in court. No, you can just correct it. It's still the slip rule. So, but you should know that what you cannot correct, you can things that are fundamental in the decision to change the nature of a decision. So, friends, it's been a wonderful class today. We don't want to know your comments. If there are other issues you want to discuss, I can also drop it for us to know. Thank you for always stopping by to know what's new on the channel. I appreciate you all. Please keep staying safe and always strive to be the best, whatever you're doing, put in my effort. The sky is just a stepping stone. You can always be the best wherever you are. Excellence is the watchword to take care of yourself.